When transferring personal services contract funds from a Medicaid applicant to a paid caregiver, whether that's a child or multiple children or a friend or family member, whoever that contract is with, should they take that money and just put it directly into the caregiver's personal bank account? Or should the caregiver be opening up a separate account for the specific purpose of holding the personal service contract funds? That's what we're going to get into in this video. So the question the daughter might have is, because we need to prove when we're submitting a Medicaid application, not only that the money was transferred out, so we're providing dad's bank statements, but we're also providing daughter's corresponding bank statement to show that the money was received properly. Okay, so multiple bank statements from two different people, at least two different people, are going to be needed when utilizing the personal services contract. So the question is, do I just stick this into my personal account? From the daughter's perspective, do I just receive this money into my existing personal bank account where I do my normal everyday banking? Or do I open up a new bank account for the purposes of holding on to this personal services contract money? The answer to the question is it really doesn't matter. There's no requirement that you open up a separate bank account just to receive this large chunk of money. There's no real benefit, practically speaking. Now, there is a benefit from a privacy perspective, because since we are going to be asking the daughter in this hypothetical example for proof that she received the funds, which is going to be in the form of a bank statement or a transaction history, the daughter may say, well, I don't know that I want, maybe the lawyer, but maybe not the government, knowing how much money I have accumulated, right? Because they may have significant savings. And so because I don't want any more personal information than necessary, like my bank account balance, being viewed by anyone else other than myself, maybe for the purposes of this exercise, I will open up a bank account that's just separate, that starts off with $0, and it's just for the purposes of receiving the personal service contract funds, and that'll be fine. As long as dad's name is nowhere on that account and daughter's name is on the account, that's okay. So that's one reason why some of the children of my clients want to open up a separate account. It might also be, sometimes we have a personal services contract that's with dad and two or more children. So let's say son and daughter, not just daughter, right? Well, they may say, instead of splitting the money equally 50-50, let's put the money aside in a separate banking that we open up and co-own together. That's another reason why sometimes people will open up a separate account just for the purposes of receiving personal services contract funds from a Medicaid applicant, such as their parent. So hope that answers the question. It's not required. You can absolutely commingle again, in our example, the daughter can commingle personal service contract payments with her regular, ordinary, run-of-the-mill bank account that she uses every day, that she's used for many, many years. There's nothing wrong with that, but we'll need that bank statement, the balance, to show the receipt of the money. And if that's okay, then we're okay with it too. There's no need to open up a separate bank account, but you can if you wish. Hope that clearly answers the question. If you have any other questions about Medicaid planning, estate planning, or probate anywhere in the state of Florida, this is what we do, and we're here to help. If you like this video, please like it and share it and subscribe to the channel. It helps me get good information out to Floridians to make everybody a more educated legal consumer. Thank you for watching.